Hello everyone, welcome to this session. So in this session, I will be taking some part of your polity questions which appeared in this year's GS paper 2 mains examination. If you look at the polity part of this year's paper, around 10 questions have appeared in polity in the GS paper 2. So I will be taking some 3 questions from that portion. The remaining questions will be taken by our other faculties, Mr. Ashish sir and Mr. Piyush sir. So let us have a look at the question first. So the first question which I'll take is this one. The most significant achievement of modern law in India is the constitutionalization of environmental problems by the Supreme Court. Discuss this statement with the help of relevant case laws. Now, this question is a short question. It is 150 words. So we don't need to go into a lot of details over here when we talk about the cases or something. But we have to cover all the important points which are mentioned in the question. Okay. Now, first of all, before actually discussing this question, a small observation on this question which I can make over here is, if you look at this question, generally when we are studying, either if you have studied the environment topic many times while preparing, we are going through some of the Supreme Court judgments. But when we study polity per se, we don't study this topic at a place where we are discussing all the important judgments of Supreme Court with respect to environment. So in this question, if you see, either you could have used all your information which you have about the Supreme Court judgments. Some judgments we always refer when we are discussing the fundamental rights, where Supreme Court declared right to environment as a part of Article 21. Then we refer to some judgments when we talk about public interest litigations or judicial activism, which has resulted into cleaner environment. So we could use some of our information which we have from those areas to write this answer. Or there was a very important pointer which came in news this year only. So in my opinion, this question is again, it may seem to be something which is static, but it is very clearly coming from current affairs. There was an article in March, I think in some newspapers about a Supreme Court judgment, where in that article they had talked about some important principles which have been evolved by the Supreme Court over a period of time with regard to environment. So in my opinion, it was definitely a question from current affairs, which if you had followed it, you could easily attempt it. Okay. So let me look at the question again. The question is asking you that Supreme Court, its judgments have resulted into constitutionalization of environmental problems, and you have to comment upon whether this has been a very significant achievement of modern law in India or not. Okay, so there are two parts. One part is talking about this constitutionalization of environmental problems as a significant achievement of modern law in India, and second part we have to show how Supreme Court judgments have resulted into this constitutionalization. So what we can do is, we can have a short introduction over here where we can just, you can say, try to emphasize on what is the question asking. Okay, so when we say achievement of modern law, now remember, in today's time, what is the biggest threat we are facing as a human civilization? No doubt it is climate change. Every other problem which we talk about, you will see that different countries have differing opinions on them, but on climate change, at least everyone, notionally or in whatever sense, they are agreeing that yes, it is a problem. The degree to which the problem is, the kind of threat which it is making, and the kind of response we have, it may differ with different countries depending upon their own situations. But there is no denial of this fact that climate change has been acknowledged as a major threat today to humanity. So when we are talking about Supreme Court's judgments with regard to environment, definitely we can say that yes, it is a significant achievement of modern law. So with that note, we can start the answer. Okay. Then we have to focus upon this word, constitutionalization of environmental problems. Now remember, when we talk about constitutionalization, it is actually related to the word constitutionalism, which we generally study when we are preparing for this exam. We know what is constitutionalism. When you start studying polity, the fundamental word constitutionalism, it comes into our discussion. So constitutionalism, remember, it means two very important things. One is limited government, and second is it is lack of arbitrariness. So you have to show that Supreme Court, through some of its important judgments, has introduced some limits to the powers of the government or the state with regard to their actions in the field of environment, and the Supreme Court has introduced some rules or principles which have to be followed whenever any decision is taken in the field of environment. So to eliminate any arbitrariness in that field, that we have to reflect in our answer. Okay, so let us have a look at how to approach this question. Okay, so we will have an intro, a very brief one, say in one line, some 15-20 words. We can write that climate change or environmental problems are the most significant challenge to humanity, where the Supreme Court, through its judgments, has brought some sanity and has ensured that climate is protected, or we are taking some step towards sustainable development. On these lines, you can frame an introduction. Okay, then you can talk about the constitutionalization. Of environment problems. Okay, so as I told you, there are two very important aspects when we talk of constitutionalization of things or constitutionalism: limit to the power of government and lack of arbitrariness. Okay, so you have to show how the Supreme Court judgments have resulted into these two things when we talk of environment, right? Now, a very brief background we need to be aware of before attempting this question. You know, Supreme Court judgments, it came mostly in the 1980s and 90s. Of course, there were some judgments before that also, but the most significant judgments which we will talk about in this area, they're coming in the 1980s and 90s, and even today they're continuing. So one of the most important developments which took place in our constitution with regard to environment, it was the year 1976. Before that, 1972, what had happened, we all know. It was the that Stockholm Conference. So after that, the significance of environment dawned upon us. And in 1976, we added Article 48A to the Constitution, where the state is now duty bound to protect the environment, forest, lakes, etc. Okay, we also added the fundamental duties, and Article 51A, there was a clause which expects all the citizens to protect the environment, right? So in the light of these two significant changes which were brought to the Constitution, and of course we had some subjects in our concurrent list. Okay, in concurrent list we had entry 17 and entry 17A and B. They are talking about environment. Okay, 17 is talking about prohibition of atrocities towards animals, 17A is talking about protection of forests, and 17B is talking about protection of wildlife. So very clearly there were provisions in the Constitution which were requiring the people. So I think it is 51G which is talking about environment. Okay, 51AG. So fundamental duties we had the DPSP which was requiring the state to protect environment, and there were some subjects in the concurrent list basically putting the onus on both the state as well as the union to protect the environment. So in the light of these things, the Supreme Court gave some landmark judgments where it brought some sanity, it brought some rules, it brought some principles to decide any dispute with regard to environment. That is what we have to cite in the answer. Okay, so one of the most important judgments which we could write in this answer, first one, the first principle which was used was, you know, right to environment was a part of right to life under Article 21. Okay, now this forms the base of everything. Once the Supreme Court declared that right to environment is included in the ambit of right to life, then it became very clear that if the state is making any law or any policy which is depriving any individual of his right to life, then the Supreme Court can strike that down, whether it is an executive decision or a legislative policy also, if it is violating the right to life, isn't it? We all know what is the purpose of right to life. So Supreme Court first of all linked right to environment with right to life through some various judgments. Any one or two you could have quoted that to mention in this answer. So one of the first cases was the RLEK versus State of UP 1982. You will find various names to this case, Dehradun quarrying case, and you may find 1985, 1988 multiple, because there were different judgments coming on the same issue over a period of time. So this could be cited. Then you have Charan Lal Sahu case 1991, and you had Subhash Kumar versus State of Bihar case 1991. So you could cite any one of these cases to mention that through these cases the Supreme Court declared that right to environment or right to life is a part of right to life. There are more cases. You have the MC Mehta case. Lot of cases are there with the name of MC Mehta versus Union of India. So any one or two cases you could have mentioned to show that through these judgments the Supreme Court declared that right to clean environment, right to clean water, air, they are a part of right to life. So henceforth, if the state makes any law which is depriving our right to life, that is, which is curtailing the environment, which is reducing the quality of environment, the Supreme Court can scrutinize it in the light of Article 21. Okay, so this was the first important legal principle which we had to show in this answer. Okay, then there were some other important principles which were used by the Supreme Court to decide some environmental cases. Basically, the Supreme Court introduced all the concepts which were introduced in the Stockholm Conference and other global reports on environment. So the principles like polluter pay, precautionary principle, intergenerational equity, all those principles were used by Supreme Court in deciding those cases. Okay, so the next principle, and as I told you, there was an article in, I think it appeared in the Hindu in March, where in single article they had mentioned all these principles. So if you had followed that, of course, you would be in a position to attempt this question very well. So it was the polluter pays principle. Okay, now the polluter pays principle, it was used in various judgments of the Supreme Court. What is this principle all about? If any pollution is caused by any, you can say industry or any kind of development activity, ultimately the responsibility lies on the polluter himself. He has to pay it. He has to bear the cost of it because he has reduced the quality of life of all the other people. Okay, so this polluter pays principle, it was used in the MC Mehta versus Union of India case. Now there are many cases which are of this name. Okay, you have some cases in 1985, 86, 87. Okay, the Ganga Tanneries case. Then you had the Shriram fertilizers case, which is also known as the oleum leak case. Then you had the Taj trapezium case later on, 2002. There are many cases where this concept of polluter pays was used with the name of MC Mehta case. Okay, और भी कुछ cases थे. There was Vellore Citizen Welfare Forum. Okay, this case 1996. In this case also there were tanneries located on the banks of the river in Tamil Nadu. So they had again used this concept to direct all those polluters to make the payments for it. So you could write that the Supreme Court in this judgment used the polluter pays principle and penalized the likely polluters for that issue. Okay, so you could use these cases. There are more cases, but even if you just write one or two of the MC Mehta case or any one of this Vellore Citizen Welfare Forum case, it could be sufficient for it. Now, next principle which was used by the Supreme Court was precautionary principle. Okay, precautionary principle. Now, what is this precautionary principle? It means that if you are doing something which is whose effects are not known, if you're doing something, it may cause some problem which we simply are not in a position to know right now. Something new is being done. Then in that case, we have to make sure that unless there is any doubt on what will be the exact result, we should not allow any such project. So this was the precautionary principle which the Supreme Court has introduced in the environmental cases. Now, a very good example of this precautionary principle was the Narmada Bachao Andolan case. In this case, what happened? We all know the Sardar Sarovar project in Gujarat, it was challenged. So the Supreme Court in this case used this principle and said, we already have had enough number of dams made by human beings since thousands of years. So it is not that we don't know what will be the likely impact of a dam. So in this case, we are using this precautionary principle and we are allowing the dam to be built because we know what can be the likely consequences. Okay, but the same principle was used in another case, S. Jagannath case, where shrimp farming in the coastal regulated zone area, it was prohibited because we don't know what can be the likely result. So even if you just quoted one of the judgments and said that the Supreme Court used this principle to decide an important issue of environment, then you could be very easily placed in this answer. Okay, very well placed in this answer. Next important principle which the Supreme Court has used is the public trust principle. Okay, now what is this public trust principle? It again means that whatever resources are there, whatever environmental resources we have, it is basically belonging to the people, and the state is just holding it as a trust. It is the state which is holding the resources of the people because of trust. So the state cannot destroy it without any, you can say, regard for the future generation. So the public trust doctrine, it is also coming from this intergenerational equity concept, right? So the Supreme Court used this doctrine. There was a very famous case, MC Mehta versus Kamal Nath case. Okay, this is again 1997 to 2000. There were 2 or 3 judgments on the same issue. So even if you just mentioned MC Mehta versus Kamal Nath case or the Span Resorts case, what had happened in this case? There was a resort built up which belonged to the some relatives of the then Environment Minister, Mr. Kamal Nath, in the 1990s. So the resort was built in the banks of River Beas, and it was they had tried to change the course of the river. So because of that, a lot of problems were faced in the vicinity. So the people had filed the complaint, and in the case, Supreme Court used this public trust doctrine, and they imposed a very heavy penalty on the resort owners, and they called them to shut it down. Okay, so these are some of the important principles which you had to mention in this judgment, in this case, and mention about the judgment where this principle was used to ensure that there is some, you can say, principle, or there is some rule, there is some regulation through which the environmental decisions are taken. And the last one which you can mention is about the NGT. Okay, it was the Supreme Court judgments which were finally resulting into the NGT, National Green Tribunal, in 2010. So Supreme Court judgments in the MC Mehta case, 1986, then in the AP Pollution Control Board, versus MV Naidu, this was 1999. In these 2 cases, and there were some more cases where the Supreme Court had called for creating a special court or a special bench where experts will also be sitting with the judges to decide environmental cases. And as a result, the NGT was created in 2010 finally through the NGT Act, which is based on the principle of polluter pays. And it has experts as well as judges as members. So my whole purpose of mentioning all these cases was that at least you can, even for future, you can refer to some of these judgments, you can refer to some of these cases to, write some more, there can be questions in future also. And of course, it does not mean you have to mention all these cases in the answer, but even if you could write these principles and explain some 2 or 3 cases that where these principles were used, you could have scored very well in this question. Okay, so there are 3 very important points. First of all, you have to make this statement very clear that it is climate change is a big problem, and that is why the environmental laws, it is a big contribution of modern law in India. Second, you have to explain what is the meaning of constitutionalization over here, and thirdly, you have to elaborate that through Supreme Court judgments. Okay, so I hope I have been able to make this answer very clear. Now, next we can move to the next question. So the question, let us first of all go through it. Again, a very long question. But again, before we start, if you look at the question and if you look at the syllabus very clearly talks about some topics like salient features of the RPA. It talks about comparative features of some other constitutions of the world. If you look at the previous year questions and you look at the syllabus, you will find that over the last 4-5 years, UPSC has been diligently asking at least a question from all these topics which are directly mentioned in the syllabus. ठीक है, तो आपको ये ध्यान देना है कि सिलेबस में जो चीज़ें साफ साफ लिखी हुई हैं, एटलीस्ट वी नीड टू हैव an idea on those topics. Okay, now again you cannot go and study the whole RPA in details, that is not required. If you look at the question again, I would say there were a lot of things related to this topic, particularly in news, which were a pointer that this topic could be important. Okay, there were 2 or 3 important cases in news with regard to election disputes. One of the disputes was with regard to Mrs. Mamta Banerjee. She had filed an election petition for cancelling her, cancelling the elections in Nandigram, which took place last year in 2021, where she lost by some 1900 votes. There was an election petition again in some other constituency in West Bengal, where another candidate of the TMC had filed it, and later on she was declared to be a citizen of Bangladesh. I think it was Alo Monarani, with some similar name. Then there was an election petition with regard to Mrs. Kanimozi, who declared a winner in 2019. So there were some 2 or 3 very important petitions which were in news in the last 1 year or so. That is why this issue, it is not a surprise if you look at this question. Okay, so if you had gone through any of these newspaper articles, you could have very easily understood what are the issues which are being talked about. Now, let us go to the question. So, discuss the procedures to decide the disputes arising out of the election of a member of the parliament or state legislature under the representation of People's Act 1951. So first part is very clearly asking you, discuss the procedures to decide the disputes arising out of the election of MPs and MLAs under the RPA 1951. Then, what are the grounds on which the election of any returned candidate may be declared void? Okay, so first of all, it is asking what is the procedure to decide a dispute. Then it is asking what is the ground on which it can be declared to be void. Then, what remedy is available to the aggrieved party against the decision? Refer to the case laws. Again, the question is very clearly saying refer to the case laws. Okay, so it will be an understatement if we say that the Supreme Court judgments, I'm not talking about every day what happens in the Supreme Court, but the Supreme Court judgments which are coming, it becomes a very significant portion for us to study as a part of polity. If you look at the prelims questions over the last 2-3 years, there have been substantial number of questions coming from matters related to the judiciary or things which are in news but not exactly studied as a part of polity. Okay, so they are giving a lot of weightage to the Supreme Court judgments also, because naturally it has become a very important part of our legal system, right? So we have to show what are the remedy available to the aggrieved party against the decision and refer to the case laws. Now let us have a look at how to approach this question. So first of all, in intro, what can be our approach in the introduction? Okay, so in the introduction, since it is a long question, we can give a decent introduction to it. Ultimately, what is the purpose of all these laws which we are having? What is the purpose of all these procedures and election disputes? The purpose is to ensure free and fair election so that democracy is intact. Why? Because if people are not elected freely or fairly, people will lose the trust in the democratic setup. Okay, so you can start on that note, that free and fair elections, ensuring transparency in the process, is a hallmark of a vibrant democracy or something of that nature. You can start on that note. Then we can talk about the different aspects of the question. So the first one was talking about procedures for resolving the disputes. Procedure for resolving the disputes in elections. For MPs and MLAs under RPA 1951. Okay? So first of all, we have to address this part of the question. So what is the procedure to resolve the dispute? Now remember, you also have to have an idea of a very, very important article in the Constitution, which is often ignored when we are studying this portion. It is the Article 329. Okay, so what is the Article 329 talking about? If you go through the article, it very clearly says that any law which is made to decide upon delimitation or for the election of the MPs and MLAs, it will be beyond judicial review. And any dispute which is coming out of any election for the MPs and MLAs under the laws made through Article 327 and 328, it will be decided only by an authority as decided by the Parliament by law. Okay, so this is the provision of Article 329. So accordingly, the Parliament provided in the RPA 1951 that all election disputes, so earlier there was a provision for election tribunals, but the Constitution was amended in the 19th Amendment Act, and now the provision is that Parliament provides for the High Court to become that forum. Okay, so Article 329 provides that any dispute, it will be decided as per law made by the parliament, and the authority will be provided by law by the parliament. So we come to the RPA and the relevant section which is talking about RPA 1951, section 80 and 81. Okay, again you don't need to remember the section over here, but I am just mentioning this because you may refer to these sections. Again, this is a topic which it will be very unlikely if you just read Lakshmikant and write this answer. You simply don't have an idea. Okay, so section 80, it says that any election dispute, it can be resolved only through an election petition. Okay. Any election dispute, it can be resolved only through an election petition and nothing else. Right? So this is the first section, and section 81 is providing you some of the procedures through which this election dispute can be taken. Okay? So this election petition, it can be brought only by two types of people. One, any candidate in the election, anyone who filed his nomination or her nomination in the election, or any registered elector of that constituency. Filed by any candidate or an elector of the constituency. Okay? Elector is the legal word. Generally we use voter, but legally there is a difference between elector and voter if you go through section 62 of the RPA 1951. So the election petition, it can be filed only by a candidate who participated in the election. Even if he was rejected, he can file because he is a candidate, and an elector of the constituency. Within how many days? Within 45 days from results declaration. Okay, so an election petition, it can be filed only after the elections are over. Please remember this very, very carefully. Very clearly, section 81 says an election petition can be filed only after the results of the election have been declared. And till when? Till what period? Till 45 days after the election is declared. So here again, the question was very clearly asking you, explain in the light of Supreme Court judgments. Okay, so here you can elaborate with a very important judgment of the Supreme Court, N.P. Ponnuswamy case, (1952). Okay, the N.P. Ponnuswamy versus returning officer of, I think it was a case from Tamil Nadu. In that case, the Supreme Court had held very clearly that no electoral dispute will be resolved till the time the election is not over. An election dispute can be resolved only through an election petition. Okay, so it was, I think, N.P. Ponnuswamy versus returning officer of Namakkal from Tamil Nadu. So you could mention this, that in the N.P. Ponnuswamy case, the Supreme Court held that an election petition is the only method to resolve a dispute unless there is something which is vitiating the election. So what is the meaning of this? Until and unless there is something which is damaging the entire election and it will be said to be unfair, the Supreme Court or the High Court, nobody will interfere in the way the Election Commission is conducting the elections. Okay, so that is the first relevant judgment which you could show, because see, the question is very clearly asking you to mention through case laws. So I am giving you some of the important case laws. Maybe this was a very difficult one for a polity student to write. It may be written by a law student but not by a polity student necessarily. But कुछ और cases हैं जो आप बाकी जो provisions हैं उसमें आप definitely mention कर सकते थे as an example. There could be very easily 2 or 3 cases mentioned in this case also on the basis of whatever information you generally collect for preparing this topic. Okay. So first one, this you could mention. Why Supreme Court said so? We have discussed Article 329. It very clearly says until the elections are over, nobody is going to interfere. Election laws, very clear. Judiciary is not going to intervene. Election petition can be resolved only, election dispute can be resolved only through an authority provided by the Parliament. Okay, so you could cite one of these cases that only it is the election petition through which it could be resolved. Next, what are the other things which we have to write here? So section 81 talks about the procedure that you can take it only within 45 days after the elections are over. Now, the question was also asking you, what is the remedy available to the petitioner, to the person who filed the dispute, in case you are not satisfied or you are not happy with it. So the dispute is going where? Section 80A. It provides that High Court is the authority to decide election disputes or election petitions. Okay, so all the disputes with regard to the election petitions, they will be going to the High Court under section 80A of the RPA. If you are not happy with this judgment, if you are not happy with this judgment given by the High Court, then you can appeal in the Supreme Court. You did not need to write all these sections, you just need to know what is the provision. So the matter will go to the High Court. If you are not satisfied, you can go to the Supreme Court in appeal. This was about the procedure. Now very important is about the grounds. To decide okay, so what are the different grounds on the basis of which we can file an election petition? So the grounds you can very easily see, they are mentioned in the section 100 of the RPA 1951 and to an extent section 101. Mainly you have to mention about the 4 grounds which you find in section 100. Again, sections are not important, the grounds are important. So what are the grounds on which a candidate's, you can say any individual can file an election dispute and the election can be declared as invalid, or another candidate can be declared as a winner of the election. So there are 2 options which the High Court has with it. It can either declare the elections to be invalid altogether and call for a repoll, or it can also declare one of the petitioners as winner of that election. Okay, so what are the grounds? If the returned candidate was not qualified, okay, what is the meaning of this? Who is the returned candidate? The candidate who has been declared winner. So if the candidate who was declared as winner of the election, if he was not eligible to become an MP or an MLA, then he was not qualified. So on that ground, the election can definitely be declared to be invalid. Then if the candidate or his agent or anyone with their consent used any corrupt practice This is the second ground. If any of the candidates used corrupt practice during the elections. Okay. So what is corrupt practice? It is defined in the section 123 of the RPA. Bribery, undue influence, using of government machinery, then promoting enmity between communities, seeking votes in the name of race, religion, caste, etc. All of these are declared to be corrupt practices under section 123 of the RPA. And it is here that you could give 2 or 3 examples of cases. Like the Indira Gandhi versus Raj Narayan case could be one example. Then there was a very important case, Ramesh Prabhu versus Prabhakar Kunte, where the candidate was declared to be disqualified because he had used religion to seek votes. In the same case, Mr. Bal Thackeray was also held guilty for this. Okay, so you could talk about this. Then what are the other grounds? If any candidate was wrongly, any candidate's nomination, if any candidate's nomination was wrongly rejected. Okay, so if you go through the RPA, there are 2 important things which we need to know about the nomination of candidates. One is that if a candidate's nomination, if any candidate, if he filed the nomination and his nomination was rejected under section 36, there is scrutiny of nominations. So at the time of filing nominations, the returning officer, he may declare that the candidate's papers are not correct, he is not qualified to become an MP or an MLA, or he has not followed some of the procedures required. So that candidate is declared to be invalid at that time. Now suppose any returning officer takes a decision and disqualifies some candidate and their nomination is rejected. Later on, if this candidate files an election petition that my candidature was declared wrongly, or any other person files the petition, then the entire election can be cancelled. No candidate can be rejected wrongly. The whole election will be cancelled in that case. But suppose if any candidate was not qualified and his candidature was accepted wrongly at the time of nomination, unless he was the one who became the winner, or his nomination being accepted affected the elections materially, that is, he got so many votes which could have changed the result, then only the election will be declared invalid. So what is the difference? First one is, if any candidate's candidature is declared wrongly, then automatically the election will be declared invalid. The whole election will be cancelled. But if any candidate was not qualified and his nomination was accepted positively, unless that nomination being accepted has affected the election because he got so many votes, it will not result into cancellation of the whole election. Okay? So the fourth ground, it is talking about the election being materially affected. Election being materially affected. Okay? So this is a very important ground, election being materially affected. Now again, you don't need to go into further details. It provides what are the situations when material effect on the election can take place. The second case which I was citing was one of the grounds over here. If a candidate has been wrongly accepted as a candidate and that results into a lot of votes shifted to that candidate, it may be called to be materially affecting the election. So these are the four grounds which are provided in section 100, on the basis of which an election dispute is decided. Okay. Now if you talk about cases, I told you one of the cases which you could write was Indira Gandhi versus Raj Narayan. (1975). In this case, the Supreme Court held the candidature of Mrs. Gandhi in the 1971 election invalid. The Allahabad High Court held so, and the Supreme Court gave her partial relief. So this case could be used. Here, what was the ground? Corrupt practices where government machinery was used by the candidate. Okay. Then you could give Ramesh Prabhu versus Prabhakar Kunte case. (1995). This was a famous case in which the Supreme Court had held that Hindutva and Hinduism, they are different, and Hinduism is a way of life. All those judgments came in this case only. So here, the candidature of Mr. Ramesh Prabhu, it was declared invalid because he was found to be using corrupt practices, as he and his election agent, they had sought votes in the name of Hinduism. Okay. Then there are some, so primarily you could talk about these cases. Then if possible, you could have talked about some other things over here, because when we talk about a candidate being qualified, so you could mention a few judgments with regard to disqualification of candidates, like Office of Profit, or there was a news about this mining lease in Jharkhand. So you could cite one or two judgments on that ground also. Yeah, एक और judgment इस पर आप लिख सकते थे. There was Uddhav Singh versus Madhav Scindia case 1976, where Madhav Scindia's candidature was held valid. So two or three, one I told you about the NP Ponuswamy case, and two or three judgments on this. You could very easily write a good answer on this. But again, in my opinion, if you have not followed the current affairs and you have not gone into the details of the RPA, then of course this could be a tough question for many people. Okay. Now, coming back to the questions, let us have a look at the third question. Discuss the role of the Election Commission of India in the light of the evolution of the Model Code of Conduct. Now, this is again a simple question. Here, if you have gone through the Model Code of Conduct well, if you know the Election Commission's powers and its features, Article 324, you could write a very good answer in this case. And again, unfortunately, just by reading Lakshmikant, maybe this topic would not be dealt with. we have got enough material. This topic has been very well covered in our material, and in fact in our classes also we have covered it very well. So if you look at this question, the role of Election Commission of India in the light of the evolution of the Model Code of Conduct. So basically there are two separate things which are being you can say merged in the question. You have to explain the role of the Election Commission and its powers, and you also have to show that in the light of the Model Code of Conduct. Okay, so let us have a look at the approach to this. Again, in the introduction, you can highlight the importance of the Election Commission. In no uncertain terms, it is one of the most important institutions which has ensured that the trust in the democratic setup, despite all the hype and criticism of the various provisions of the elections, the Election Commission has ensured that there is faith, there is peaceful transfer of power every year in many states in the country, and of course in every 5 years or a shorter period in the Lok Sabha. Even a country like USA could not see a peaceful transfer of power 2 years back. So that is a testimony to our Election Commission, isn't it? So on that note, a brief introduction about the role of the Election Commission could be said over here. Then you could talk about the Model Code of Conduct. So first of all, talk about the EC, and in one line you can talk about the MCC, the Model Code of Conduct. What is it all about? And then you can try, so there can be different approaches to write this answer. One you can first of all explain the Election Commission and its powers, and then talk about the MCC, or you can first of all talk about the EC and MCC in brief, and then you can go on mixing the two. The Election Commission and this power, this can be seen through this in the MCC, something of that sort. So I am first of all dealing with the Election Commission's powers, and then I will explain the MCC. Okay, so Article 324, if you go through, it is the most important article with regard to the Election Commission. Okay, the single article which talks about every aspect of the Election Commission, and the first clause itself, this article has 6 clauses in it. The first clause itself, 324(1), it talks about practically everything about the Election Commission's powers. It uses 3 very important words: the superintendence, direction, and control. Okay, so it says that the Election Commission has got the power of superintendence, direction, and control of the election process. So once the election is notified, once the election has been declared, the Election Commission has got complete control over the election process. So the whole election process, right from declaration of elections, then conduct and declaration of results, okay, this entire process, it is in the superintendence, direction, and control of the Election Commission. So first of all, you could highlight in very brief about the role of the Election Commission in this entire process. What do you mean by superintendence, direction, and control? And then you could cite Supreme Court judgments on this issue again to highlight the importance of the Election Commission. You could also talk about Article 329 and Supreme Court judgment. Again, Article 329, what does it say? It says that, any law made by the Parliament, it is even beyond judicial review when we talk about conduct of elections. So Supreme Court, using that article, has refused to intervene in the election process once it is notified. Once the elections are starting and the Election Commission is controlling the elections, Supreme Court has said that Article 324(1) is a reservoir of powers for the Election Commission. It can do anything which it finds fit to conduct the elections. So there are some very important judgments of Supreme Court on this. You have MS Gill case 1978, Mohinder Singh Gill case 1978, where you can talk about Supreme Court judgment in single line. Supreme Court held that the Election Commission has all powers to conduct the elections. Unless something vitiates the elections, it will not interfere. Similar judgment was held in other cases. You have ECI versus Ashok Kumar case 2000. In this also, Supreme Court held the same thing. The Election Commission has wide powers. They will not intervene in the election process unless they are feeling that the election itself is vitiated. So first of all, write about in brief about the Election Commission and the 3 important words mentioned in the Constitution. Then what the Supreme Court has to say on Article 324. It is a reservoir of powers. These two judgments or any one judgment you could just mention to elaborate upon it. Then in very brief mention about the different types of power the Election Commission is exercising in the field of election. So it is having quasi-judicial powers, it is having administrative powers, and advisory powers. Okay, you don't need to elaborate this in details because you also have to write about the MCC. So practically about one page you can write about the EC, 1 page or something like that, some 100 words. Then you come to the MCC and there explain how in the MCC the Election Commission has used these powers in its evolution and use. Okay, so what is the MCC? First of all, you can in very brief talk about it. Either you have written in the introduction or you can write about it over here. It originated as you can say a code to be followed by all the parties in Kerala. Okay, do's and don'ts. Do's and don'ts in Kerala for parties. This is how it originated in 1960. Then it was circulated for all parties in 1962, assembly elections in Kerala. Then in 1967 it was used by the Election Commission. And 1979 is a very significant year when the Election Commission, it modified the Model Code of Conduct and brought some more concepts into it. Okay, so it added some provisions to prevent the party in power from getting advantage in elections. Then finally 1991 under Mr. T.N. Session, when he was the CEC, the MCC was modified and implemented in the present form. So this is the whole evolution. You could simply write it originated as a do's and don'ts for parties in 1960 in Kerala. In 1967, it was used by the Election Commission for all parties. 79, it was expanded, and 1991, it was modified and implemented in the present form. Next, you could write what are the important dimensions of the MCC and where is the EC coming into picture. So the various aspects of the MCC, what are they? So it is talking about election process in general. You have nomination, you have poll campaign, meetings, processions, polling day, polling booth. It is talking about party manifesto and party in power. Okay, these are the different areas which are covered by the Model Code of Conduct. So you can very briefly first of all mention what are the areas where it is dealing with. Then you explain how the EC comes into picture. Okay, so what is the role of the EC? The EC, it declares the election. When is the Model Code of Conduct coming into force? With the declaration of election. So MCC is coming into force through EC declaration. Okay, formal notification comes later, but it is coming into force by the declaration of the Election Commission itself. Then you can talk about what are the important areas where the EC can intervene. So the most important areas which you can mention in the answer is transfer of government officials, okay, during the elections. So the EC plays a big role. Once model code of conduct is set in, the transfer of government officials, the EC has an important role. Once the model code of conduct is put into place, no major policy decision, okay, no major policy decision can be declared by any party, especially the party in power. Then you can talk about some other very important steps. You can give some examples, like recently the election commission, it has taken action against people who are using hate speech in the campaigns. Okay, so why it is important, why the EC's power are very important, you have to explain that at least in 2 or 3 lines. Remember, MCC is not a law, no legal value. Okay, though the Supreme Court has accepted its importance in the Harbans Lal case in 2000, but it is not legal in nature. You cannot go to court for violation of MCC during the election. Remember, during the election, the EC has got wide powers, as the Supreme Court has said. So if anyone is violating the model code of conduct, it is the election commission which can take action at that time itself without even going to a court. So this aspect you have to explain, that MCC, it helps the election commission to fight any problems during the elections. You don't need to go to court for it. So some people demand that the model code of conduct should be converted into a law. That does not become a very, you can say, good prospect, because it will deprive the EC of many of its powers. Okay, so on these lines you can write about the EC's role over here, its role in transfers of government, to stop any major policy decision. If somebody has to take some very important policy decision, they will have to seek the go from the election commission, and it is able to deal with problems of violation of the MCC during the elections, because you don't need to go to court for it. You can give some examples. So this is how you have to write this answer. Okay, so I hope you have understood how to approach these questions. Thank you very much for this session.